The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Good morning from Las Vegas, and welcome back to another episode of RapidVisa Live, where we try to answer your immigration-related questions. Once again, I want to remind you, we're not attorneys, we're not a law firm. We are licensed and registered and bonded to do immigration document preparation in Nevada, and we're happy to answer your questions based on our over 10 years of experience and having done over 45,000 petitions. But if you need legal advice, this is not the place. Probably no place on the internet is the place for legal advice. If you need legal advice, by all means, get an attorney. Okay, now we're going to once again offer a $100 credit towards any future RapidVisa service, selected randomly among the comments or questions that you post for us during this broadcast. If you don't have a question, that's okay too. Just put a comment there saying, "Hey, enter my name in the drawing," and no comment or question is necessary to participate. Okay, so we're coming live on YouTube and on Facebook, and so enter your comments, and we have monitors watching right now, and we'll try to get to all of them we can. We're going to jump right in here. Looks like we have one already, or an announcement anyway, from Rick. And with me today, as usual, is Rick, and my name is Ben. I'll pass it off to Rick.
Thanks. We'll start off with some news this week. USCIS announced on February 15th that it's publishing guidance for its officers to consider when adjudicating spousal petitions involving minors. The guidance, published as an update to the adjudicator's field manual, clarifies age requirements for a petitioner filing an affidavit of support for a spouse in conjunction with concurrently filing the I-485, and identifies factors officers should consider when adjudicating the Form I-130 spousal petition involving a minor. So basically, this means they're going to be scrutinizing petitions involving marriages with minors. So basically, you have to be legal in the country where you're getting married or celebrating the marriage, and you also have to be legal in the state where the couple plans on residing or living. But it sounds like they're going to publish some guidelines for the officers to use when they're adjudicating these petitions. And the actual post that we received or read did not specify any ages at this time. We do expect more information to come in the future. But just keep in mind, if you're involved in a marriage and filing a petition for a minor, they're going to scrutinize it more, and you'll want to make sure that you're legal in both the country where you're celebrating the marriage as well as in the United States.
Okay, good note. It's an important topic, and I'll say that while there are many states in the United States that will allow, with certain levels of consent, will allow marriage to a person under 17 or under 18. Sorry, if you are engaged or married and want to do a petition for somebody who's under 18, don't call us. Don't come to our website. We don't want your business. Okay, now let's take the first question. Is from Olapi Pupo. Okay, sorry, I'm sure I didn't get that right. But question is, does a fiance visa applicant, now a spouse, waiting on a green card have the ability to travel or work before the green card is granted? So that's a great question and a common question. Not surprised we have that one right off the bat. The answer is no initially, but once you file for the adjustment of status, that Form I-485, you can and should also at that time file for work authorization and what they call advanced parole, because they can't just use a simple name like travel permit. And that, once you receive that, which now is is generally combined on a card, a combination work and travel card. Then you can work and travel. Until you receive that, you can't do anything. I say you can't. You can certainly leave the country, but then you will have forfeited the whole K-1 visa. And so it's very important that once you enter on the K-1, you do not leave the country until you have that travel permit or the green card, whichever. You don't have to apply for the travel permit if you don't want to. You should, because there's no additional fee when you file it along with the I-485. But so you might as well. There's nothing to lose. But you don't want to leave. And we've had that happen before. Mom gets sick back in France or wherever they're at, and so all of a sudden the lady, the immigrant, needs to leave to go tend to an urgent situation back home. Well, now you're starting all over. If you've gotten married while you're in the U.S., you start over with a spousal visa. If you haven't, you do another K-1, but you've got a problem. So yes, you can work and you can travel after you get the authorization, but before that, no. You definitely don't want to work because you're not authorized to work, and you don't want to travel because you're not going to get back in the country without going through another visa process.
Okay, Hassan Ali Ashraf states that I'm from Pakistan. After the interview at the embassy, my case went into administrative processing for 3 months. What is really the purpose of the administrative process, and why is it taking so long? Good question. We do receive this quite a bit as well. Administrative processing is basically a way for the consular officer to say that they do not have enough information available or enough supporting documents and evidence to adjudicate your case. Basically, that means they don't have enough to approve your visa at this time. And in many cases, they will send your case up to like a supervisor or manager for further review or additional review. In many cases, administrative processing also involves an RFE, that's a request for evidence. So I wouldn't be surprised if you received a letter asking for additional supporting documents or evidence, proving you have a bona fide relationship or the sponsor meets the income requirements. And to speak to the time frames, there's really no documented time frame for administrative processing. I can tell you from our experience, most cases are usually answered or resolved within 4 to 8 weeks. Even the National Visa Center states that you must wait 60 days after your case has gone into administrative processing before even contacting the embassy. You stated yours has gone on for 3 months now. I would recommend contacting the embassy just to find out where it's at, or maybe even check the status online, because maybe they've already sent your case back to the USCIS. But you'll want to follow up on that. Don't wait much longer. Contact them. You can also submit an inquiry online by going to the U.S. Embassy website, and they'll have contact information there. But I would definitely follow up on this and find out what the current status is.
Okay, we have Elizabeth from YouTube asks, my friend married in Nevada, lives in California. Husband used to abuse her physically and mentally, has been separated for more than 10 years. Can she apply for any kind of visa? She is not divorced. Okay, well, I don't, we would need to know how she entered the country. Just marrying an American citizen really gets you nothing. If she entered illegally, or she's illegally present, or she entered legally but she's overstayed, all of those things matter. So no, just because you happen to be married to a citizen doesn't really do anything. There are other things, like if you entered illegally, if a person enters illegally and then gets married, that doesn't automatically make anything right. That does give you an opportunity to try and apply for a waiver of inadmissibility and then try to go through that process. Not something we could help you with, but an attorney could help you with that. But if you're in an illegal status or an out of status and you're now married but you're separated from that spouse, and we assume that spouse is not going to cooperate, then you may not even have the ability to get a waiver. I don't know. That's way out of what we do. And we would have to know more about it. But at the end of the day, I'm assuming that this person is either out of status or entered illegally, which means the only way you're going to rectify that is with the help of an attorney. It's not something we could help you with.
Okay, Sherry Ann Hamlet states that I'm currently in the U.S. Will there be a problem if I file for AOS now after being married for 2 years? If so, will I have to do the removal of conditions? Well, to answer your question, we'd have to probably require a little more information, knowing how you entered the United States, what type of a visa you came in, what your current status is. Are you in a lawful status right now, lawful permanent? Since you stated you're applying for AOS or asking about AOS, I assume that you entered on maybe a tourist visa or student visa, something like that, and then you got married. I can tell you this, you may be able to file for adjustment of status, but the USCIS is scrutinizing these cases more so now than we've seen in years past. So you may want to give us a call, contact us, and provide us a little more information, and we can probably point you in the right direction. But it really comes down to how you entered the United States, what your current status is. But in most cases, we have found that if you haven't broken any laws and you entered in the United States, you were inspected, meaning you entered legally, you should be able to adjust your status. And then you also mentioned removal of conditions. Well, if you receive a conditional green card, meaning that it's valid for 2 years, then you could file removal of conditions after you meet the eligibility requirements. But that comes after you usually get your green card, and then you can file and apply for a 10-year green card. But your first green card is usually a 2-year green card, and it's usually issued with conditions, and that's why they call it a conditional green card.
Okay, we have Benita from Facebook ask, can I sponsor my husband if my housemate gets Social Security benefits at my address? Yes, certainly. If your housemate is just your housemate and not a family member, just your roommate, housemate that shares the rent or whatever. I mean, yeah, sure. Just because they get a Social Security benefit at your address, it's certainly not uncommon that people share an address. So, yeah, if it's as simple as you're saying, and they're not related to you, this is not a spouse, this is not, a family member, and you're gonna, it could even be a family member, as long as it's not somebody dependent upon you. So if it's not somebody you're claiming on your tax return, you're not claiming them as a dependent, they're not dependent upon you financially, they just happen to be living there in a kind of a roommate situation or housemate, as you say. Shouldn't matter. It doesn't matter what they're doing with their life and their finances. Okay,
Ivy on Instagram asked if RapidVisa can help those who already filed I-130 and received their approval notice. Absolutely. We receive calls every day requesting assistance for the National Visa Center stage, the embassy stage, and we can pretty much help you at any stage of the immigration process. In most cases, depending on your situation, we can gather up your documents. We can also help you with the DS-260, the affidavit of support, your civil documents. So basically, when you get into the National Visa Center stage and the embassy stage, it gets a lot more complicated than the USCIS stage. And we've also found that a lot of people do file their I-130 with the USCIS directly without assistance. Some customers actually use some of our competitors, maybe where they just provide software only and do not provide the full support like RapidVisa does. We actually support our customers from in all stages, including the USCIS stage, National Visa Center stage, as well as the embassy stage. So absolutely, give us a call or go online, create an account, answer a few questions in our online questionnaire, and let us help you out. We'd be happy to do so.
Okay, Deanna from YouTube asks, is there such a thing after an interview, somebody could get their visa stamp to get approved immediately? Okay, so by that I guess you mean the visa, which is actually not a stamp, it's a sticker. It doesn't matter, but I just want to clear that up. Well, I mean, the short answer is no. It doesn't work immediately while you're in the office, and of course, it's going to depend on what type of visa you're looking for. If you're going to get a tourist visa, they will generally tell you immediately if you're approved. However, you're still going to be a few days. It has to be printed up. It's a kind of a security proof, a decal that is the same size as a passport page. You'll leave your passport with them. They'll stick it in there. And it's usually, depends on the country, there's so much variation, but 3 to 5 days or so, it'll be available for you to pick up, or it might be delivered to you by courier. I mean, that's how it works. So it's really not the case that you walk out with it even if you're approved. It doesn't quite work that way. And so you definitely don't want to go making plane reservations, anything like that. Wait till you have it in your hand, because you're not generally going to walk out with it. Now, are there exceptions in an emergency situation or something? Who knows? There's always exceptions to everything. But generally speaking, in every case that we know of, you don't walk out with the actual visa that moment. But, within a week, you should have it.
Okay, Zara Lena states that we are currently processing our spousal visa application. I have worked in Saudi Arabia and UAE. Do I need to get police clearance? The answer is yes. You will need police clearances or certificates from any country that you have worked or lived in since age 16. Now, there are some exceptions to the rule. There are some countries that state that you're unable to obtain the police certificate if you're no longer living in the country. And since you lived in multiple countries, you'll want to check that. You can check online, go to the U.S. Department of State, which is travel.gov, and you can pull up the reciprocity schedules and select your country, or either Saudi Arabia or UAE, and you'll find out exactly if those documents are available, how to obtain those documents, what the fees are. It outlines the entire process for you. You can also give us a call and we can look it up for you. But yes, you do need police certificates from every country that you've resided in or worked in since age 16.
Okay, we have Joseph on Facebook asking, my fiance from China now has a B1, B2 visa, that's a tourist visa. Is it possible to wed in the States and then file for the spousal visa? Yes, it is possible to wed in the States, but you wouldn't file for a spousal visa unless she plans to go back to China. So there's two scenarios. It's not clear in your question, so I'll discuss both of them. You could definitely get married in the United States, and then she goes back to China, and you file a spousal visa, and she waits there for that whole process to work its way through. Or you can marry in the United States and do an adjustment of status instead of a spousal visa, which is where you're basically adjusting your status from B1, B2 visa to lawful permanent resident. And that's usually what people mean when they ask this question, which is quite common. So yes, she can stay. Now, I would be remiss not to mention that your intent is always important. If you intend to use a tourist visa for the purpose of immigrating, that's not correct and could cause you problems. Generally it doesn't, but theoretically it could. In other words, they want you to use the correct visa. So if you're in China and you're thinking, hey, I'm going to use my tourist visa to go to the United States and get married and stay forever. In other words, I'm going to immigrate. Well, then what they would tell you is, look, that's not the purpose of a tourist visa. The purpose of a tourist visa is come over here with your camera and take pictures of the Statue of Liberty. If your intent is get married, you should stay in China spousal visa. So intent is important. But if you're here on a tourist visa, you meet somebody, you fall in love, you want to get married, absolutely just do adjustment status. We do those all the time, probably several a week, in that exact same situation. Tourist visa, student visa, some kind of non-immigrant visa. They marry a U.S. citizen and now they want to change status to lawful permanent resident, which is green card holder. Pretty straightforward process, no problem.
Okay, Mario Cruz asks if I can apply for a fiance visa even if I don't have a job, as long as I have a joint sponsor. This is quite common, and yes, you can apply for a fiance visa regardless of whether you're employed or not. Now, once you get to the embassy stage and where you're expected to submit an affidavit of support, which would be the I-134 form, and as well as supplying your supporting evidence, you're going to run into a problem because they do have a minimum income that is required to show that you can support the alien beneficiary that you're sponsoring. You basically have to prove and show that the alien, your fiance, is not going to become a public charge and collect means-tested benefits. Now, in your case, you may be able to obtain a joint sponsor. That is anyone that is 18 years of age, a U.S. citizen, or a lawful permanent resident, and they can sign the affidavit of support. But you would still have to file an affidavit of support regardless of whether you're employed or not. Now also keep in mind that some countries do not accept joint sponsors. I can give you an example. The Philippines, or the U.S. Embassy in Manila, does not accept an affidavit or a joint sponsor for the fiance visa. They do accept it for the spousal visa though. So you'll want to check on that first before you go in and apply for a fiance visa. Make sure that the embassy that you'll be going to for the interview does in fact accept a joint sponsor. But to answer your question, yes, you can file for the petition. It's just you're going to have to need to prove that you can meet the income requirements at the embassy stage.
Okay, we have Lucy on YouTube asking, after getting the NVC case number, what is the deadline to get all documents uploaded before the case is thrown out? The NVC generally gives you a year, and it should say that in the document you got. Obviously you want to move things along as fast as you can, but technically your case will stay active for 1 year from the time that it was established. In other words, when they generated and issued your case number. So you got a good long time, but there's all kind of good reasons why you don't want to wait. One of which is the underlying USCIS approval that you got, and you didn't say if this is spousal visa, fiancé visa, but it really doesn't matter. So for example, if this is a spousal visa, when you got that approval from the USCIS, it's got a 4-month expiration date. Now, generally, as a matter of procedure, they usually automatically extend them without you doing anything if the process itself is what's causing a delay, which it usually is, right? But they don't have to. They just do that. And so while you've got a good long time, usually a year with the NVC, that your case will remain open, the USCIS approval that underlies that, if you take a look at that approval letter, you'll see that they're generally only good for 120 days. So for about 4 months. So we don't really see them denying petitions because the USCIS approvals expired. Again, that's because they will automatically extend them because they know that generally it takes more than 4 months to get through the process, right? But if it's you dragging your feet, they certainly could. So I would get to it right away. And the second thing I'd say is, if you do get correspondence though from NVC that says otherwise, then obviously listen to that. Like if you send in documents, they ask you for more information because it's incomplete or inadequate. If they put a deadline on that, by all means, you never want to miss a government deadline. They're not. When a government gives you a deadline or a date, it's not a suggestion. It's your fun is over if you miss this date.
Okay, Suado Alif on YouTube asks if you can apply for the fiancé visa if you have a felony. And the short answer is yes, you can apply. But you're probably going to want to look up a document and a regulation. It's called the International Marriage Broker Regulation Act. That's IMBRA is the acronym for that. And the IMBRA document actually outlines the criminal convictions and criminal history that is looked at, because IMBRA is basically a law that was passed to protect alien beneficiaries and from crimes like sexual abuse, any harm to humans, things like that. If you're also on the Adam Walsh Act list, you will automatically be denied. You can look that up as well. But look up IMBRA, and you'll basically see a list of the crimes and convictions that they scrutinize, that they look at, that could prevent you from filing. But in our experience, felonies would not prevent you from filing, and in most cases they don't even cause a denial. More than likely, once you get to the interview stage at the embassy, they would ask you to produce the criminal records and dispositions. You would provide the police reports and all court documents, court records, and they're going to share those with the alien beneficiary. That's the foreign fiance. And so you'll basically want to discuss these crimes, convictions with the alien beneficiary, just so they're aware of them, because they'll probably be asked about them at the interview. But that's really what they're looking to do is inform the alien beneficiary and also protect the beneficiary. And IMBRA provides great detailed information on everything they're looking for regarding the criminal history and convictions.
Okay, from YouTube, Overdale from YouTube says, I have all the vaccinations, but the physical record got lost. My health institute doesn't have any records. Can I be denied without the record? Well, it's a little more complicated than yes or no. Okay, so let's start at the beginning. Number one, you are not required to get the vaccinations at the medical exam that you will do before your embassy interview, but you are required to get them. Well, it doesn't say what kind of petition it is, but you will have to get them before you apply for the green card. So if it's a fiance visa, you can skip them, but you're going to have to get them later. To get the green card, which is the ultimate goal, right, whether it's through a fiance visa or spousal visa or parent visa or whatever, you are going to have to either have evidence of the vaccinations, which means you're going to have to do it again. They're not going to take your word for it. If you have no records, you got to do it again. Or you can request a waiver. Now, there's a fee for that. We don't do those, so I always forget what the fee is. $300 something. It's not free. And if you object to vaccines, but so I don't want somebody to chime in and say, no, wait a minute, you don't have to get the vaccines. If you want to go down the path of asking for a waiver, paying a fee, and paying a fee that'll probably be a lot more than it costs you just to get the vaccines, that's up to you. So that is a possibility. But for most people, yes, if you don't have any records, you're going to have to go get it again. Unless you can go to that whoever issued your vaccine and they can reproduce it or redocument it or whatever, then maybe you'll be okay. But otherwise, you're just going to have to get them again. And I'm certainly not a medical professional, but we've had a lot of people do that. So it appears that there's no harm in getting them again. Again, don't take my word for it, but yeah, bottom line is they're not going to take your word for it. The government doesn't really take your word for anything, right, on these type of things. So if you can't somehow come up with the documentation, just get them again. Check with a medical professional, make sure it's okay, but then get them again might be the easiest way to resolve this. Or again, you could look into a waiver. It's not something, again, we could help you with, but we do know that we have had customers who have gone down that path. It may cause you a delay. It will definitely cost you a filing fee. So those are your options as far as we know.
Okay, Faith on YouTube states that my husband and I have an age difference of 18 years. We're both Muslim. Would that be a problem for our visa to be approved? We're currently at the USCIS stage. Well, I can tell you it wouldn't be a problem at the USCIS stage. We have actually had quite a bit of experience with age differences, especially from countries in Southeast Asia. But we have noticed, quite a few RFEs, requests for evidence, and denials coming out of countries from Africa and in the Middle East, where there was a large age difference. And it was usually when a female from the United States was petitioning for a male that was much younger in one of these high-risk countries, what's considered a high-risk country where there's a lot of immigration fraud. Usually age difference is not that big of a deal, but we have actually seen denial letters out of Africa stating that it was against their culture. It was not normal to have an age difference, between the male and female. But again, it depends on the country where you're, plan on attending the interview. You could give us a call and maybe we could provide more information. But like I said, most of the cases that we see do have large age differences, but it's usually a male from the United States petitioning for a female from South America or Southeast Asia, somewhere like that. I would just give us a call and we could probably point you in the right direction.
Yeah, I would add to that 18 years is not, in this business, not a large age gap. It's probably low. That's probably less the gap than average. So I wouldn't worry about it at all. But like Rick mentioned, where we do see it is when there's a large gap and the petitioner, U.S. citizen, is a female and the alien is a male, and then there's a 20, 30-year gap. There does appear to be a very clear gender bias, which in my very non-legal opinion should be illegal, right? That's probably a case somebody ought to take on. But our records, and again, we only know of the cases we handle, but in our experience, there's very clear gender discrimination going on against females because we never, I don't know any documented case in our 45,000 or so we've done where we've seen age mentioned as an issue when the male is 20, 30 years older than the female, but we definitely see it the other way around. I don't know how you don't call that gender discrimination, gender bias or something. So there you go. But 18 years, again, is not the numbers I'm talking about. Where we, even with the gender bias I mentioned, where we see it is when there are bigger gap, over 20 years or so. 18 years is probably not in the range that you need to worry about. Okay. Sohail Khan from Facebook asks, my fiance and ex-husband joint accounts so I can use for the affidavit of support. My fiance and ex-husband so I can use. I'm really not clear. Maybe you can clarify it, but I'll answer what I'm guessing is you want to use your fiance and your ex-husband both want to be your sponsors. I mean anybody who is resides in the United States and is a U.S. citizen or green card holder, 18 years or older. Anybody that meets those requirements, 18 years or older, resides in the United States, and is a green card or U.S. citizen holder, can be your joint sponsor. Anybody. There's no exclusions. Could be your child, could be your parent, could be your friend, could be a stranger you met on the street. Anybody who's willing to sign that document can be your joint sponsor. So absolutely your ex-husband can be. Absolutely your fiance has to be. If you're doing a K-1 visa, your fiance has no choice. Even if they have no income, they have to sign an affidavit of support. So yes, pretty much anybody that meets those requirements can be your, and obviously has the income, meets the income requirements, could be your financial sponsor.
Okay, Joy states that I came to the U.S. on a K-1 fiance visa to marry my fiance. Before we married, I had to rush back to the Philippines to tend to my sick kid. Can I extend my K-1 fiance visa, and how can I go back to the U.S. now? Okay, to answer your first question, no, you cannot extend a K-1 fiance visa. That is a one-time use visa. It's a one-entry visa. After you used it and entered the United States, it's null and void. It's expired, and you cannot extend those. And you ask how to get back to the United States. Well, you stated that you left before you married. Therefore, you're going to have to start all over again. You'll either file for the K-1 fiance visa again, or you and your fiance can marry and file for a CR1 spousal visa. But unfortunately, you're going to have to start all over again. And this is the main reason why we always recommend that you get married as soon as you come into the United States and file for that adjustment of status as soon as possible, because we hear this scenario all the time where someone comes in and they have a family emergency and they have to leave before they marry or get their green card. And it's, a lot of people put this process off, the adjustment of status process, for too long, and then they get caught in this scenario that you're caught in. So unfortunately, you're just going to have to start all over again, and we'll be happy to assist that with you, or assist you with that process if you choose to do so.
Okay, we have one asking, what can disqualify me from the U.S. citizenship? Okay, so, well, of course, so if you're a green card holder, you can't become a citizen until you've been a green card holder for 3 to 5 years, depending on your situation. So you never go directly into citizenship. But if you're here already and you're a permanent resident, or that's your plan for the future or whatever, and you want to become a citizen, what can disqualify you is, of course, any felony conviction, it generally doesn't happen, but it could. It's in the list of things that you can be denied for. So if you've committed some kind of felony and you apply for citizenship, they can deny your citizenship. For that matter, you can be deported if you hold a green card in many cases, and it has happened where somebody's green card is revoked and they're deported. So felony convictions, although it appears they would have to be pretty serious before anything like that happens. Any kind of fraud, of course, in obtaining your green card, which of course you have to apply for citizenship, or in obtaining the citizenship itself. So if you frauded the government in any place, even if it's years ago, we've seen cases. There was a recent one, I don't know, probably been over a year ago, where somebody had been a citizen for, I think it was over 20 years. But back in the original application, they had lied about. There's a whole lot of questions about a lot of things that the government's concerned about, including your involvement in wars and human trafficking and torture, killing, being a Nazi, whatever. So any of those things could get you denied, but also lying about them. So they ask, there's all kind of odd questions. I mean, they seem a little odd, like, have you ever engaged in prostitution? If you say no and it turns out you have, or they find out, not only can you be denied citizenship, it can be taken away from you, even if you've lived a life here, which again has happened. Now, it's rare, but these are things that can cause you to get in trouble. If your criminal associations, if you're a known member of some bad group, the mafia, whatever, things like that. I mean, they're looking at your character, and a character is hard to definitively define. If you've got good character, you're a good person, you haven't been involved in these kind of serious crimes, you really don't have to worry about it. It's most people who apply for citizenship, you've already been through a vetting process to get the green card. You are probably going to be approved. If you pass the little civics test and you speak some English, you're probably going to be just fine. Now, if you're not going to be surprised, is what I would say. Anything that would deny you, about. That is, you've been involved in something horrific, or you've lied to get to where you're at right now. You got involved in a fake marriage to get here and get your citizenship, something like that. So you would know about it. You're not going to be surprised. If you're denied, you're not going to say, wow, I didn't know that. You're going to say, dang, they found out. So I wouldn't over worry about it. Most people are approved unless again, you've got something very bad, or you've lied to gain citizenship or gain green card or even gain the visa that got you here. If you lied anywhere to the immigration people along the way and they discover it, yes, you may very well be denied and deported.
Okay, Aisha Shaw on Facebook states that after my interview, my spousal visa is in administrative process for 4 months. Would I be approved or what? My CEAC status showing refused, but I called the embassy and they said it's still an administrative processing, and I have to wait till it's completed. That's correct. If they tell you you have to wait, I mean, you really have no other choice. But I can tell you, most cases are usually adjudicated. They're either approved or denied or sent back to the USCIS, usually after 60 days. So you actually have taken the correct steps in contacting the embassy, and that's really all you can do. I'm somewhat surprised that the online status says denied, and they're telling you that it's still in administrative processing. But I can tell you from experience, those online status sites that you go to, they're not always up to date. We've also discovered recently that there's a backlog of cases and they're just not getting to them. And we're also hearing that administrative processing is taking longer now, whereas it used to only take 30 to 60 days, and now we're hearing it's taking longer. But all you can really do is just keep contacting them, and find out where it's at. A couple of things are probably going to happen. Either they're going to approve your visa and it'll be issued within 5 to 7 business days after the approval, or they're going to send your case back to the USCIS for further review. If that's the case, that usually takes about 2 to 3 months for your case to go back to the USCIS. They'll look at it. They can either reaffirm the case and send it back to the embassy, or they'll just tell you that your case has expired, the validity period has expired, and then they'll issue the official denial notice. But basically, the administrative process is just where they're looking for more information or looking for enough supporting documents and evidence to approve your visa case. And in most cases, in our experience, we've seen that administrative processing also involved an RFE, or a request for evidence. You didn't state that you received anything like that, but again, just keep following up, and that's really all you can do at this point.
Okay, McCoffey from YouTube asks, my fiance had an interview in March of 2018. It's now a year later. Our visa is under administrative processing 220G. Had her police clearance and examination clearance. Will that get expired? Wow, very similar to the last question. Let me say that everything is taking longer now. Assumably that's due to this more careful vetting or extreme vetting that's going on. But a year is still longer than a year is still a long time. Obviously, the best thing I can advise you is try to contact the embassy, whatever that entails. You don't mention what embassy, but whatever it takes, try to contact them and see if you can get an update. But if it's taken that long, they may have sent it back to the CIS. And when they send it back to the CIS, USCIS, U.S. Citizenship and Immigration Service, they generally send it back with a recommendation to revoke it, right? So it sounds like there's a problem. I hate to tell you. But really, your real question was not that. It was, will your police clearance and examination expire? Well, no. The clock kind of stops when they receive it. So for example, a medical exam or police clearance, if you get it and you hang on to it for a year and then you go apply for a visa, that's a problem. They're going to say it's stale. But if you got it, briefly, within the months before you submitted it, once they have it, no, it's not going to expire, and they say, hey, this is expired, you got to do it again. That's not something you got to worry about. What you got to worry about is that 1 year is way too long. Something is wrong. You need to contact the embassy, or if they send it back to the CIS, try to contact them, make an InfoPass appointment. I mean, it shouldn't take a year. We just don't see that happening. So it does appear that there's a problem there. You'll need to investigate.
Okay, Annalisa Shatham asked if I'm applying for adjustment of status. I've completed my biometrics last December 26, 2018. When can I expect my work permit and travel permit and upcoming interview for adjustment of status? Well, this is kind of the ongoing trend right now. Everything is taking longer than anticipated. I can tell you a year ago, you would probably be looking at 3 to 4 months to receive your work permit and travel permit. That's the combo card. But now we're hearing it can take up to 5 to 6 months. And the interviews now are being spread out further. If you'll go online to the USCIS website, you can go to the processing center where your case is currently at, and you can look up the processing times. And I can tell you, they're not the most accurate time frames, but right now we're seeing increased time frames across the board on every processing center. So I wish I could give you a definitive answer or a better answer. But right now, you're probably looking at another couple of months to get your combo card. And then after that, probably another month or two after you get your combo card, you should receive the interview appointment letter, and that'll come in the mail. But one thing you should do, though, don't just wait on this. We've heard too many cases where applicants just simply waited and 6-8 months went by, and the USCIS had issued a request for evidence. The applicant never received it. They never responded to it. Therefore, their case was closed. Contact the USCIS. check the status online. A lot of times they'll tell you if a letter was sent out, but I would just call them directly. You should have a receipt notice. If you'll look on that receipt notice, it'll have a contact number on there. It'll also have your case number, your USCIS case number. You can check the status online, but after it's gone for a period of time, longer than 3-4 months, I would call them. We've also heard cases where the combo card was mailed but was not received. It's very important that you contact the USCIS and let them know that that combo card wasn't received, and also make sure that they have your correct address, especially if you've moved within any time frame since you submitted your application. You'll always want to make sure you update your address. You can do that online or contact the USCIS directly, but definitely contact them and don't wait too long.
Okay, from Facebook we have Catherine says, my fiance and I have been chatting since August. He already visited me last February, stayed for a week. He's 61, no children, no parents, living alone, has his own house and cars, receives disability, $1,750 a month. Unemployed. Is he qualified for K-1 visa? He is from Oklahoma City and I'm in the Philippines. Okay, well, I don't have my calculator in front of me. We do have a calculator on the site that tells what the income requirements are. It's really the same for all 48 states. It's higher for Alaska and Hawaii. And so $1,750 sounds like, without having a calculator in front of me, it may be enough for the K-1, but then you've got to do the AOS and it becomes 125% of the poverty level. So it looks like that might be slightly short. A couple of things. Yes, you can use disability benefits. That's an earned benefit. It's not means tested benefit. In other words, that's not welfare. That's a benefit we all enjoy by paying into Social Security, and if we happen to get disabled, that's paid to us. But $1,750, again, without having the calculator in front of me, give us a call or use that calculator on our site. It'll show you what the exact requirement, 125% of the poverty level for a household of 2 people is. What Rick, off the top of your head? It's around 20?
Yes, 100% is around, no, that was actually 125%. Is 20.
Well, that's what I mean. The 125% is what you'll need for the adjustment of status. Is around 20, and it looks like he might be a little below that, but without my calculator. It's very close. However, you can use assets. You say he has a house, he has his cars. You can use assets. Generally, not your first car. I mean, there's some limitations on assets, and they only give you a credit for a third of the asset value. So if you had $100,000 equity in your house, they'll give you $33,000. Basically, is what that means towards meeting your requirements. So it sounds like he's very close. If not, of course, you can use a joint sponsor. But he may be fine. I mean, again, it's hard when you start getting into the numbers. It's hard to give you an answer on the fly. But a couple of things I can tell you is that. Yes, you can use a disability benefit because that's an earned benefit. It's not a means-tested benefit. And if he has some assets like a home or a retirement account or something like that, those things you can use. So that's the best answer I can give you. Sounds like you can make it work, though. It looks like you're close enough. You can probably figure out a way to make that work. And give us a call if you want some more details on that.
Just to add something to that real quick, with the extreme vetting that's going on here over the last 6 to 12 months, we're seeing more RFEs, more requests for evidence where the income is just barely over the minimum required amount. I mean, we've had quite a few cases come through where they were, $700, $800, $900 over annually. And they met the income requirements, but yet they still received an RFE, and the adjudicating officer was requesting a joint sponsor. Another thing to keep in mind, it is at the USCIS officer's discretion or the consular officer's discretion as to whether or not they will accept assets. We've submitted some cases with assets and they were approved, and other cases we've submitted assets and they were denied. So again, just keep in mind that everything is at the discretion of the adjudicating officer as to what they'll accept or not. When you go into this process, keep an open mind and know that there's a good chance you'll probably receive a request for evidence when your income is lower or just barely meets the minimum required amount. Okay, so Faith Primo on YouTube states that I am from Guyana and my husband is from the U.S. I'm currently not working, but at the time we filed, I was on a contract job at a call center. Would it be an issue at the interview stage for me? Well, just to let you know, Faith, you are not required, the alien beneficiary is not required to work or be employed, nor is your income counted on the affidavit of support. What is important is that the U.S. citizen or petitioner is gainfully employed and can show that they may meet the income requirements, for your petition type. So I hope that answers your question. I mean, you're asking about you being employed, but that's not important. Now, I can tell you on the questionnaire, it does ask if you've been employed, and if so, you'll enter that information into the questionnaire, and that information is transferred to the forms. But it shouldn't be an issue if you are not employed at the interview stage.
Okay, so we have Glenimer on Facebook asking, I'm from the Philippines. I came here with a J1 visa, that's exchange visa, about 2 months before June, so I guess that's April of 18. My visa expired, and I applied for a tourist visa, but I haven't received approval or denied. I got married and I'm pregnant. Me and the husband applied for the adjustment status and the I-130 last month. They just asked me for a request for evidence for my tourist visa. I didn't comply. I just send my adjustment of status. I'm confused what to do. I'm a little confused about the question too, but I think you're saying, well, first, one thing jumps out at me. You said they asked for a request for evidence. You didn't comply. You don't ever want to do that. Even if you don't have what they want, you need to respond, because if you get a request for evidence and you don't respond, they just close your case. They don't, that's it. They don't say, oh, she doesn't have it, we'll continue without it. You're non-responsive, case is closed, good luck. And you've lost all your filing fee, which was $1,225 you paid for the I-485 and 535. So don't risk that money. If you got an RFE, you always have to respond. Even if you can't respond in the affirmative, you don't have what they want, you got to respond with something. Okay, so now having said that though, yes, you came on a J1, the J1 expired. Can you get married to a U.S. citizen, adjust status? Absolutely, you can do that. It's quite common. No problems there. So that part, and it sounds like that's exactly what you did. Even if the J1 is expired, again, still not a problem. The key problem is when you enter the U.S. without inspection, or in other words, illegally, which you didn't. You came on the J1, so you're good there. You can adjust status. You'll probably be fine. Your bigger problem now is the adjustment status. You said they ask for, the request for evidence, RFE. They asked for information about your tourist visa. I don't know how they would know. Maybe they saw the application somewhere in the system, but they weren't clear on if you received it. So they're asking you. Maybe that's it. In which case you're just going to tell them, look, I didn't get it, or I haven't got it, or I haven't heard from them. Whatever the answer is, just be honest. I mean, you're in a good situation. You came on a J1. You're married to a U.S. citizen. You're in a great situation. You got nothing to hide. So be honest. Tell them everything you know. But by all means, you have to respond to these people. If they give you 30 days, 88 days, sometimes you see odd numbers, whatever it is, that is not a recommendation. You have to reply in that amount of time, or they will close your case and you'll forfeit everything you've paid. Now you can file again. It does, and try all over. But now you're paying again. The fees you pay to the CIS are for them to consider your case, not to issue a visa. So once they've considered it, whether the answer is yes or no, your money is spent and you won't get it back. So that's what I worry about right now. But otherwise, sounds like you're in a good place. You entered legally on a J1. You got married. Even though the J1's expired, you're going to be fine based on what you're saying there. I don't think you have anything to worry about. Just respond to that RFE as fast as you can. Even if the time has already passed, if you haven't yet got a denial or something, go ahead and reply anyway. Maybe there's still a chance they'll look at it, but generally, if you miss the deadline, you've closed your case.
Okay, Nietzsche91 on YouTube states that I am visiting my fiance on Monday. We just received our NOA1, that's Notice of Action. That's the first letter you receive from the USCIS. That's the receipt notice. And he's asking, could I get pulled aside and have to prove that I'm still living in Germany? I have papers to prove that. Can they still forbid me to enter the United States? I'm not sure I follow the question. I'm not sure. Are you the U.S. citizen? Well, it says no. I guess you're the alien beneficiary because you're wanting to enter the U.S. I just don't know. I don't see why there would be any issues with that. Maybe you could send us another question and explain that.
Yeah, sounds like you're visiting. I mean, if you got your NOA1 and you just came here for a visit, which is certainly your right to do, there's no problem with that at all. Just don't overstay. Generally, you got 90 days. Don't overstay, and then go back and wait for the conclusion of your visa. Now, and you don't say what you've applied for, but if you've applied for a spousal visa or fiance visa, either one, you have to be back in Germany to complete that process. You can't complete it here.
Right.
Now, can you stay here, throw that away, stay here and apply for adjustment of status? Perhaps, but you definitely cannot complete that CR1, a spousal visa or fiance visa, while you're still here. You're not going to be able to just stay here and maybe hope that they think you're still in Germany. It doesn't work that way because you're going to have to go to a medical exam and an interview back in Germany.
Now, I have heard of a case where we had a customer, a female from Canada, who was coming back and forth between Vancouver and Washington, and she had entered the United States 13 times within a short period. And the CBP agent, Customs Border Protection agent, did actually tell her to go back home and just wait for the process to complete because she had came over too many times. So I don't know if maybe that's the angle you're looking at. But to answer your question, I mean, the CBP agents can prevent any non-U.S. citizen from entering the United States. I mean, they're going to inspect you when you come in, even as a visitor. But in most cases, we haven't heard of any issues. The only time I had ever heard of anything was when the female from Canada was kind of abusing the process, if you will. But that's the only time.
Okay. Oh, this one's mine. So William is asking, the fiance and both of us are residents of China, and we're on work visas. She is Russian, and I'm an American citizen. Does RapidVisa help in situations like this? File a petition to third-party. Yeah, it's confusing. She's Russian, I'm American, but you're both residents of China? I guess you're both working in China or something? Well, anyway, no, we don't process visas for other countries, if that's your question. If you're trying to become a resident or citizen or get a visa for the United States, to enter the United States, to visit the United States, to live in the United States, that's what we do. If you need a visa for China, Russia, somewhere else, we don't get involved in that, so we can't help you with that. Okay, looks like we are nearing the end of the hour. Sorry if we didn't get to everybody. We want to have a minute here to announce our winner. And once again, this is for a $100 credit to use for any future service on RapidVisa. It looks like our winner this time is Zaralina. Zaralina. We'll write that down. You don't need to contact us right away, or you can call right now if you're ready to use one of our services, and we're happy to give you that credit. And on our way out, I'll remind you again, we're not attorneys. We have a great deal of experience doing what we do, but we can't give you legal advice. Nothing we've said during this broadcast is legal advice. And if you need legal advice, for goodness sakes, go hire a lawyer. Don't try to find it on a YouTube video or online anywhere, really. That's not good advice, and we wouldn't advise you to even use our opinion for anything serious with serious legal consequences. That's it. We'll announce our next live cast again, and we're going to try and do these a little more often. But if you didn't get a chance if we didn't get to your question, please go ahead and contact us. We're here 7 days a week, 800-872-1458, and perhaps we can help you that way, and we'll let you know what service we offer. Once again, thanks for joining our live cast. It's always interesting for us to hear your questions, and we welcome you to come back next time. Thank you. Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. RapidVisa is a document preparation firm licensed and bonded in the state of Nevada. If you need help with your immigration petition, check us out. We've helped over 30,000 customers from 180 countries apply successfully. Check out our testimonial library at RapidVisa.com, where we have over 1,000 photo testimonials from actual customers describing their immigration journey with RapidVisa. There's no cost or obligation to create your RapidVisa account. You can create your free account at RapidVisa.com/free. Be sure to like and follow us on Facebook to be notified of future live streams. Thank you, and see you next time.